So, you're thinking about becoming a guarantee/guarantor for a mortgage in Queensland? Well, this is the video for you. And here at Oneness Law, we incorporate legal aspects as well as human aspects to any matter that you are going through, if it's related to business and or property. Now, when you're becoming, or you're thinking of becoming, or you've been asked to become a guarantor of a mortgage here in Queensland, there are a number of steps that we would recommend you go through before you actually agree to go through it and become the guarantor. And step one is starting with the heart of the decision. Like, why are you considering this? Why are you agreeing to be a guarantor? Is this coming from a place of pressure, obligation, or a genuine willingness? How will this decision, and also, there's another thing to consider, how will this decision affect your emotional well-being? Your stress levels, your relationship with this person that you are guaranteeing their mortgage of. Now, the second step of the process is asking, well, what does it actually mean in Queensland? And from a legal standpoint, a guarantor in Queensland is someone who agrees to be responsible for another person's mortgage if they can't meet their repayments. So this can mean things like the bank can require you to pay the loan if the borrower defaults. So also, your assets, like your home or your savings, could be taken from you in order to do this. It may also affect your ability to borrow money in the future, and this obligation can last for many years. It could be 30 years. So these are things you may wish to consider as well. So even if the borrower is trustworthy and well-intended, life happens. Job changes, illness, relationship breakdowns. Being a guarantor means being prepared for also those possibilities. Now, moving on to the third step, which is the types of guarantees that there can be. And we're going to go over three main types. At least one of those would likely be what you are guaranteeing. And the reason we talk about these three types is because not all guarantees are the same. So the first one being a security guarantee. So you're securing your equity over your property for this borrower. The second one is a financial guarantee. This is where you can guarantee the whole loan or a portion of it. And the third one, I would say, is a limited guarantee in which you cap your responsibility of a set amount. And this is often considered the more safer option, although at the end of the day, you'd have to really sit down with your accountant, your financial planner, and your lawyer to really engage which one of those three is actually the safest for you. Now, the fourth step is requiring legal advice and independent legal advice. So not legal advice from the same solicitor that is involved with the borrower's borrowing, but a solicitor that's outside that matter. Hence why you'll often find that you'll have to go to a different law office to be able to get that advice. And this step is rather important. I mean, it's very important, shall I say. And it really gives you the opportunity to understand your risks, your rights. You have the space to ask questions openly, and you're not being rushed or pressured. This is your chance to slow down, make sure that you are stepping into this commitment consciously. Now, the next step is openly talking with the borrower. So having this open conversation about their financial stability, their contingency plan if they experience some financial hardship, how they'll communicate with you if something is not going to plan? And what do you expect if your support is ever needed from the borrower as well? Holistic law is rooted in really good communication and transparency. And these conversations can minimize, if not minimize, protect your relationship with the borrower long term. Now, the next step is checking in with your financial future. This is looking at the finances. Can you afford to step in and make repayments if they fall due on you? Would this decision affect your retirement plan? Will this change your financial goals or borrowing capacity? And how would it feel like emotionally also within yourself to carry such risk? So, being a guarantee, a guarantor for a borrower is not about you compromising your own sense of financial security or plan or intention. And then the last step is creating clear boundaries. So if you do decide to go ahead, make sure that you are expressing your expectations around a limit on the guarantee if possible. Clear communication. How is the communication going to happen? Planning also for a review of the arrangement over time. Should not just the borrower, but also your financial situation or just your life in general. Should you move into another chapter, making sure that you're coming back and revisiting this guarantee when it needs to be discussed. And also having an understanding of when and how will the guarantee be released when that time comes. So if you've gone through all of those steps, then you should have a pretty good clarity on whether you are willing and able to step in to be a guarantee/guarantor for a borrower. Now, if you need some assistance with this, you are looking at becoming a guarantor for a borrower, welcome to reach out to us. Our website is www.onennesslaw.com.au, law being LORE. And you can also reach us on our email, info@onennesslaw.com.au.